If I was arrested for a DWI in Houston, what will happen to my driver's license? Attorney Cory Roth explains. If you've been arrested for a DWI in Houston or anywhere in Texas, the Department of Public Safety will take action to suspend your driver's license. In many instances, your license suspension will be automatic unless you take steps to challenge the suspension. Once the police officer investigating you for DWI has decided to arrest you for DWI, he will read you two forms, the DIC-24 and DIC-25. The DIC-24 explains the driver's license suspension consequences for refusing to provide a specimen of your breath or blood and for your breath or blood alcohol level being at 0.08 or higher. The DIC-25 is the notice of suspension of your driver's license and a temporary driving permit. The DIC-25 notifies you that your permit or privilege to operate a motor vehicle or watercraft will be suspended or denied effective 40 days after you receive the DIC-25 notice because you either refused to provide a breath or blood specimen or your breath or blood had an alcohol content level above a 0.08. While the DIC-25 permit allows you to drive for an initial 40-day period, if you requested an administrative driver's license hearing, the DIC-25 permit will allow you to drive until the administrative law hearing judge decides whether you were lawfully detained and investigated for DWI or not, which can take up to 6 months. It is vitally important that within 15 days of your arrest for DWI, that you either hire a DWI attorney to handle your license suspension hearing or request an administrative license revocation hearing on your own. The purpose of this hearing is for an administrative judge to determine whether your license should be suspended, because the Department of Public Safety is making a civil administrative claim that there was probable cause to believe you were driving while intoxicated, and therefore your driving privileges should be suspended. As your attorney, we are going to review all of the discovery or evidence provided by DPS and you, subpoena the officers, up to 2, who investigated and or arrested you for DWI, and question them under oath about the reasons for stopping you, the reasons for investigating you for DWI, and what signs of intoxication they observed. Our goal in the ALR hearing are to examine and develop facts that will help us convince the criminal trial judge to suppress the traffic stop and or other evidence used against you, to lock the officers into his answers so that he cannot change or exaggerate them at your criminal trial without losing credibility, and to prevent your driver's license from being suspended. A great result in an ALR hearing can lead to a great result in your criminal DWI case. But a bad result in an ALR hearing does not necessarily mean there will be a bad result in your criminal DWI case. Attorney Cory Roth will ensure that every client who comes to him for assistance will leave with the best possible resolution to their case. By applying tried and true strategies to scrutinize every detail of your case, you can relax with peace of mind knowing you have the best criminal defense attorney on your side